Good afternoon. My name is Erica Bond, and I am the Vice President of Justice Initiatives at John Jay College of Criminal Justice. I'd like to thank you all for joining us today for this second webinar in a series we are calling Demystifying AI in Criminal Justice, and we are very proud to be hosting this with the AI and Justice Consortium. I am honored to welcome you to this very important conversation about how to engage thoughtfully with artificial intelligence and its impact on our courts and judicial systems. This event is co-hosted by the John Jay College Future of Public Safety Initiative, which I lead with my colleague Rebecca Atkinson, and many thanks to Rebecca for her help in putting this webinar together. It is also hosted by the AI and Justice Consortium. We invite you to learn more about both of these initiatives using the links that are being provided in the chat. I would also like to take a moment to announce an upcoming event that John Jay College is hosting with the National Urban League. It's the Safe and Just Community Summit. It's scheduled for April 14th through the 15th. This is a national gathering. It will convene change makers, including elected officials, academics, practitioners, and advocates from across the country to chart solutions that make our communities safer, more just, and more inclusive. And for those of you that want to continue to dig into the issues surrounding AI and justice, we will have a dedicated plenary panel on day 2 of the convening. So please come and join us for that conversation. The summit is being held at John Jay College here in New York City, and more information about the summit, as well as registration information, is also available using the link in the chat. So now back to today's program, which is bringing together a wonderful group of experts who are here to share their insights about the many different ways in which AI is already being deployed as part of our criminal justice processes. These experts are going to talk to us about how this emerging technology is being used to improve the work of the courts and public defenders and prosecutors. And they're also going to help us think through the challenges and issues that can arise when we introduce new technology into imperfect systems that have enormous consequences for the liberty of individuals and the well-being of their communities. And so ultimately, I believe it's important that any deployment of AI in the criminal system really needs to enhance the legitimacy of our legal processes and expand rather than restrict equitable access to justice for all. So I know we're going to have a very rich conversation today. Thank you so much for being here and for joining us for this conversation. I'd really like to thank Christopher Edley, the Executive Director of the AI and Justice Consortium, for his boundless enthusiasm for this topic. I have learned so much from him and the many experts that he engages with, and for partnering with John Jay on this webinar series. So I will now turn it over to Chris to introduce our speakers and moderate today's discussion. Thank you, Chris.
Thanks, Erica. That's too kind. I mean, enthusiastic is true, I guess. Thanks, everybody, for being here. My name is Chris Edley III. I'm the Executive Director of the AI and Justice Consortium, and we are absolutely thrilled to be holding our Demystifying AI in Criminal Justice series in partnership with John Jay. Today's topic, the courts and AI. This sits at the intersection of technology, law, constitutional rights, and public safety. And the decisions that we make today about how AI is deployed across our justice system have profound implications for generations to come. This is a new space. This is a new field. We've brought together 4 truly remarkable experts grappling with these issues from different vantage points. I'm going to let each of them introduce themselves because they'll do a better job than I possibly can. And we'll be sharing some bios in the chat. So before we get started, housekeeping. This is being recorded and will be made available after the event. Question and answer, we're going to take about 15 minutes at the end. So please use the Q&A function in your Zoom to put questions there, and we'll get to as many as we can. Lastly, we will be dropping some relevant resources in the chat throughout, so keep an eye there. With that, let's give it a go. So let's start with foundations. Can each of you panelists introduce yourself first and then choose one sort of AI application currently being used or piloted in your area of expertise, in your area of the court system? Um, Talk about why it matters, what it's doing. And I'll start with Aubrey Souza.
Thank you so much, Chris, and thank you all for inviting me to be here today. And for those of you joining, my name is Aubrey Souza. I'm a principal court management consultant at the National Center for State Courts on their Access to Justice team. So NCSC, for those of you who aren't familiar, is a nonprofit organization that supports the state courts across the country. And in part of my role, I also serve on a fellow consortium for AI Policy Consortium for Law and Courts with partnership with Thomson Reuters and NCSC, which is made up of judges and court administrators, academics, lawyers, and we publish resources and guidance on AI use in the courts. At NCSC, my role I focus on the intersection of technology, process improvement, and access to the court system. Admittedly, I do focus largely on civil case types, but I think a lot of it will be very applicable to our conversation today, I promise. And I actually am developing a few tools as part of that initiative. And so my one example I'll give you really quickly is we're working with a court in Pennsylvania that has a really fabulous credit card diversion program. So for credit card filings, they go through a different process. And the AI tool is helping the court staff go through the all of the filings. A credit card collection case can be quite lengthy in review to make sure that all of the evidence is there of the debt itself. Sometimes these cases are 12 years of debt, and that means 12 years of credit card statements. And so making sure that all of the evidence is there is very cumbersome for the court staff to review and make sure that it's all provided. And the AI tool is not replacing that review for the court staff. It's supporting that review, identifying where in the documents it is, and then directing them to where that is so they can process these cases faster than they would by hand. And I think that's just applicable to a lot of our conversations here today, where there's a lot to go through, there's a lot to do, but also the human review is always important. And so how they're balancing that in Pennsylvania. Thank you again.
Thanks, Aubrey. I'll move to Laura Bond.
Good afternoon, everybody. I'm happy to be here, and hopefully this session will be informative. I am a chief prosecutor at the Montgomery County District Attorney's Office in Texas, and we are currently using an application called AI Justice. It is an AI application. It's helpful for us because it's CJIS compliant, and so we can enter law enforcement sensitive data and still get the benefits of the AI application. It's specifically tailored to assist prosecutors and administrative staff in our office with some of our cumbersome and routine tasks. It's specifically tailored to our tasks at the prosecutor's office that we do here, and so it's a valuable tool for us that we're using now.
Excellent. And for those that don't know, CJIS is Criminal Justice Information Services. Is that the right acronym? And it's sort of what's a good analogy? HIPAA
Yeah,
for
that's it.
law.
Perfect analogy. Yeah, that's with criminal histories and sensitive date of birth type information.
Got you. So strong data governance
Yes.
there. Jennifer Salidi.
Hi, everyone, and thank you so much for having me. My name is Jennifer Saletti. I am the head public defender for the state of New Jersey. We are a 1,300 person agency within the executive branch of state government, working in criminal defense, child welfare, youth defense, mental health, a number of different practice areas. And we have been using AI for a lot of things at the Office of the Public Defender here, but one of the things that we have created is a brief bank. One of the problems that our lawyers were having is, and I don't know if this is like this in your law firms or your law practices, where you keep old briefs somewhere on your server, and people have access to them, and they kind of go through them and pull out the pieces of the brief that they may want to use to create a new brief, a process that I lovingly call Frankenbriefing. And what we were finding is that a lot of the briefs in these brief banks were stale, or if you were in one of our 21 counties, you weren't getting access to the briefs in another county. So what we have done in conjunction with Princeton University and our New Jersey Office of Innovation, which I hope to talk more about later, is build our own brief bank that allows attorneys to call up good data from other briefs that have been vetted by our appellate section from across the state. And in this way, shorten dramatically the amount of time that it takes them to kind of get the guts of the legal sections of their briefs in place. So that is something we're incredibly proud of, not just because it's solving a problem that our attorneys had, but it was something we were able to build in conjunction with a local university and by using the services available from our Office of Innovation.
Excellent. Makes me think about, we often think of data quality being quantitative. In this case, it's really that this more unstructured written word data, making sure that the briefs themselves are good and not stale. That's fascinating curation. Patrick Robinson, you're up next.
Yeah, thank you all. Great to be here. My name is Patrick Robinson. I'm the founder and CEO of a tech company called Allometric. We're building the air justice platform that Laura Bond mentioned. That particular tool handles a variety of different discovery analysis related tasks, helping prepare information that comes in a messy, unstructured format into something that's more structured, more useful for the full litigation process. So one related application that I would love to highlight around this task of turning unstructured data into structured data is something that we're beginning to test and pilot, which is looking at automating data entry. So in the same way that we can use large language models to structure information for legal professionals and the tasks that they take on, we can also use large language models to extract the key information that can then subsequently be using RPA processes actually entered into a case management software. I think there's a huge opportunity with regard to improving our data completeness, data quality across the criminal justice system by taking on more and more of that particular workflow in an automated fashion. So excited about some of these applications as well, and look forward to the rest of this conversation.
Thank you, Patrick. Thank you all. Aubrey, we're going to go to you first. Can you dig in further on use cases, maybe distinguishing between more general tools like ChatGPT and tools specifically designed for the courts and for criminal courts? Like, what trends are you seeing? What's the sort of outlines of the range of the problems that AI is helping to solve?
Yes, definitely. So I'll start with maybe first, largely courts are not going straight to the frontier models like ChatGPT, Claude, pick your poison there, and are building tools for themselves. We heard just like a few examples of how tools are being designed using AI, using these models, but for the specific use cases, which has often been kind of a challenge for courts in adopting technology. Many times they're having to retrofit, but the flexibility of AI is actually, in many cases, making it more accessible for courts to try new things. And I'm gonna like ignore, as if it doesn't exist, kind of the use by litigants and their use of those commercial models, because that is a diatribe and maybe therapy session of its own. But so courts are looking to adopt this technology and build things for themselves. And it kind of comes in like two very large categories, kind of internal, which we've talked a lot about, tools that are supporting the court in their work and their process to make things either faster or more efficient and move the cases appropriately but faster, and where many courts have a backlog. And then there's also kind of a public-facing side, and that goes to chatbots or eligibility tools that support those individuals coming into court in their understanding of a process. So that can look like an eligibility tool to understand if you qualify for a traffic diversion program so that you don't actually have to go into the docket. You can go learn if you're eligible based on your record and a few of your own preferences, and then apply rather than going and waiting for your turn to be called on a docket just to be told go apply to this online. And there's like chatbots that help somebody just understand their plea options or the information or what's going to happen in court. And they can interact with that information in the way that they understand it by asking the question that they need to ask and then getting the information where sometimes court websites, you have to kind of find that information. You don't know the language. And so people are able to come to court with a better understanding of the information that they need and are more prepared. And then in kind of like a future hope that a lot of courts are thinking about and we're thinking about partnership is making things a little bit easier. So where there's fee waivers and affidavits of indigency, is there an opportunity to just automatically look for that instead of having to fill out a form, knowing that you even have to fill out that form and moving through that with the parties in a case and making that happen automatically with all of the information that we have. We know that people receive benefits and many times that automatically qualifies them. So can we automatically do that to support the individuals coming through court? So there's internal, making it work better for the courts and the people who support those systems, and then also those who are interacting with it. I think there's a lot of opportunity and excitement, and there's a lot of people trying some cool things right now.
Interesting. Thank you. Patrick, back to you. You support prosecutors and defenders. Are there differences you see in what they need, the priorities they have, the problems they're trying to solve, or is it sort of mutually applicable in general?
Yeah, absolutely. Well, I think at a level of abstraction, I think there are similar challenges. They both inherit really messy data from a variety of different sources, and then they have to use that information, that data, for criminal litigation. So at that level, there's certainly commonalities. Whenever we approach a problem, though, I mean that's really the key nexus point. We have to define what problem we're trying to solve and at what layer of abstraction we're trying to solve it before we start considering how an AI tool could solve that problem. So just really important that we start first and foremost with that problem definition, explore the context around the problem, and then start exploring specific solutions. When we think about prosecutors, in some ways what they're looking for is sort of the greatest hits. They want to line up the evidence against the elements in the case. They want to try to understand how witnesses will testify with regard to their observations, how it relates to actually getting evidence in trial. The defense counsel have the fundamental opposite approach. They're not often trying to admit evidence. They have no burden of proof. So their goal is often to look for ways to challenge the proof that the prosecutors are offering up. They're looking for more the needle in the haystack. How do we undermine the credibility of key witnesses? How do we demonstrate that there's more confusion about what happened than the prosecutor's approach to a particular case? So those end up being, in some ways, pretty different, even though at a high level of abstraction, they're fairly similar. One great use case that defense counsel have put LLMs to use on are creating mitigation packets. And because there's sort of this affirmative proof case in that particular area, it's actually somewhat similar to what prosecutors are doing. So they're taking large volumes of medical or mental health records or other sources of mitigation evidence and then summarizing that so that they can offer it in sentencing if necessary. Defense counsel are more looking, or pardon me, prosecutors are more looking for, like I said, lining up proof to elements. So how do we get this kind of unstructured, messy data actually in front of the fact finder? And then both groups are often using these types of tools just to get a faster handle on an insurmountable workload. Both sides, prosecution and defense, face compounding volumes of evidence with how digital evidence now works, whether it's audio or video or actual text case file. So both sides are just trying to wrap their heads around what is in a case file as quickly as they possibly can so that they can make smart decisions on behalf of their client. Prosecutors, their community members, and defense counsel, their specific client in a particular case. So overlap, but distinct and really necessary to focus on the problems.
Interesting. Laura, your office, the Montgomery County, Texas DA, is very advanced and very ambitious. So using a tool or a use case to explain, can you talk about the actual interaction, the sort of day-to-day, the nuts and bolts, the fingers on keyboards that your prosecutors have with AI, and the sort of, who, in quotations, sort of anthropomorphizing the AI, but who should be doing what and how you strike that balance?
Yeah, absolutely. In our office, we treat AI as an assistant, not a decision maker, right? Prosecutors still own every single judgment call that we make. That's charging decisions, credibility assessments of witnesses, trial strategy, ethical obligations. Where AI helps currently is more on the administrative tasks, kind of like Patrick mentioned, and organizing large volumes of discovery or helping draft, first pass documents that prosecutors can then review and edit. It's helping with efficiency, but the balance is being super clear about roles, right? AI can help us work faster and more efficiently, but it doesn't decide what's fair, or what's just, or what we can prove beyond a reasonable doubt, right? So AI handles, let's say, repetition and scale, and prosecutors handle judgment and accountability.
Right. One thing I think about is that it's humans do justice. There's no way to remove
Right.
that responsibility
Right.
or fact. It's just simply not justice if it's a computer doing it.
Correct.
Fundamentally human thing. Getting a little philosophical, I guess. But Jen, I think it's the same question to you, and I guess it's just about responsible use. Are there any tasks that AI can fully take off defenders' plates, or is everything hands-on?
I think there are tasks. And I think what you said about being human really gets to the core of at least our philosophy here, and the way that I think it should be is, how do we keep humans involved? And how do we use AI to give attorneys back more time to spend with the people they represent, right? Like every decision that we're making, everything we're doing is so that our lawyers can spend more time with the people that they serve, and we can automate the mundane, the routine, the administrative tasks. But when you ask the question about, what tasks can be automated, the answer is every single one. There is not a thing an attorney does that I can't think of a way that we could use AI to augment that process. But at the core, and as Laura said, there still has to be a human being making a decision. So for example, body camera footage, right? We get hours and hours and hours of body camera footage in the smallest case up to a first-degree murder. Back in the day when I was trying cases, I would have to watch it, then I would have to watch it again, and I would have to make handwritten notes of where the things were and where Jen's face showed up and all of those things. Attorneys still have to watch it. We can't take that away, but maybe the AI then can go back in and find where Jen said this or the police officer said that, right? So for us, it's been really important that every time we do a training about anything, even if it's just a training about body cameras or just a training about mitigation, we talk to lawyers about how you could use AI to augment that process, and we give them step-by-step procedures for using the AI responsibly, so that we don't run afoul of the rules and we don't have people short-circuiting the human nature, the human decision-making that we have to do. I think on the other side of this, we talked about the difference between public defenders and prosecutors. I think there is one very key difference in the roles of defenders in the system, and that's that we are a sword and a shield, right? So we're using this technology affirmatively, but we also have to be defensive, and that's where public defenders are a bit unique. We are seeing a rapid proliferation of predictive policing tools, of forensic tools that are aided by AI, of facial recognition technology that has a lot of fundamental flaws in the algorithms. There's all these technologies out there that are being used to convict our clients. So I think another part of responsible use when it comes to public defenders is keeping out technology, keeping out from courtrooms technology that should not be used to convict people in a court of law. So our lawyers have this double challenge of using AI on the offensive, but also figuring out ways and knowing the technology well enough to defend against improper uses in courtrooms.
We'll get to that fair fight in just a moment. And I'm excited for it. But Aubrey, I want to come back to you, and I think that you think a lot about how do you know when AI is the right solution? What goes through your mind, what should go through others' mind as they're looking at a problem and trying to think, is AI helpful here?
Yeah, so I think actually Patrick, Jennifer, Laura all just went right through exactly what we think about for anyone who's deciding like, is AI the solution? But maybe I'll put like a short but finer point on exactly what those questions were that I heard from our fabulous colleagues here today. I think like first everyone started with what is that problem we're trying to solve? Tons of data, mundane tasks are some of the examples that we heard. And then they said, who is it for, right? It's for the professional attorneys. And so is going through that data the best use of their time, or is it interacting with the individuals that they represent or with the victims, the people that actually make up what a court case is about? And so who's going to use it? How is it going to be used? Who is it going to impact? They're thinking about all of those things. And then they said, okay, is AI the solution? And they also said, like, is technology the solution? And then for what parts of it? Should it be all, or can it be all? Maybe, probably. As Jennifer said, yeah, it probably could be all of it, but it doesn't necessarily mean that it should. And then AI is just one of the technology tools that we have now. And I'm sure inside of all of your stacks of your tools that you're using, there are things that are not AI, that AI is helping do that better, but there's also pieces that AI might not be the right thing, and you're using it where it's the best tool, but it's not the only tool. And so I think everyone's like given really great examples of how that's applied, and just making sure you kind of start from not how should we use AI, but what is the problem we're solving, and is AI part of the solution?
That's great. I think a lot these days about product design as a concept, and it's a field, and hoping to do consortium programming around that. Love to involve you all. So fair fight. Criminal courts in general really are intentionally adversarial, as everybody's sort of been getting to. And I want to consider the tension of that AI presents in that space. So Laura, as a prosecutor, I don't need to tell you that you need to have a worthy adversary, right? It's not just that you want to win right, I believe. I know that because I know you a little bit. So you have a responsibility to the people to use every tool in your belt to get convictions. But how should we be thinking about the balance about maintaining a fair fight from the prosecutor's perspective? And then relatedly, how should we approach inconsistencies between different district attorneys' offices when it comes to implementation, when it comes to available tools? Is that enough? Does that track?
Yeah, no, that's perfect. And,
Okay.
I think it starts with remembering that a prosecutor's job isn't to just win, it's to see that justice is done. And a fair fight depends on both sides being prepared and able to test the evidence. And AI can help with that if it's used responsibly, especially where resources are uneven. Where we have to be careful is making sure AI doesn't create new disparities between offices. So that to me means transparency about how tools are being used, clear policies for human review, recognizing that AI should assist the legal work and not tilt the outcomes. at the end of the day, the legitimacy of any conviction depends on confidence in the process, right? If AI strengthens that confidence, it helps the system. If it undermines it, then we've used it wrong.
Jen, following the prosecutor, you're on defense again. No, you're the defender. Similar question. Public defense, indigent defense, and even private defense. It's a patchwork system. In a lot of places, it's jurisdiction to jurisdiction, state to state, federal system. So in theory, AI can help ensure this fair fight, improve the fairness, augmenting defenders. But what's it going to take to get us there? What are the biggest challenges?
Yeah, I think there are resource challenges. I mean, I'm in a state agency, a statewide agency, so it's a little bit different for us than small county-based public defender offices or systems where there's no centralized public defender's office at all. And those offices are relying on sort of per diem attorneys or attorneys that are on some sort of list or panel. Where we're seeing it in New Jersey, because we do have this centralized system that is fairly well resourced in this department. We see big law firms being able to take advantage of it. We see our statewide agencies being able to take advantage of it. The people I feel like are getting lost are small solo practitioners, many of whom do what we call pool work for our office. So they'll take conflict cases for our office. So I think that there are challenges and opportunities, right? I think there's opportunities for courts to step in and offer lower cost tools to some of those folks. I think there's also opportunities for using tools that are free or very low cost and just being creative about how those tools are being used. I think another sort of challenge to an agency like ours is scale over time as we start to add AI tools and we start to build out more and more tools. And we're using everything from the tools we're building, like the one I discussed, to Westlaw AI, to our own internal kind of brand of ChatGPT. There's a lot of tools that keep coming online, is scaling our workforce. So one of the other things that we've done here is start to retrain some of our support staff into being liaisons between IT and legal offices so that we can use them to help support the expansion of AI. So I think two things that anyone can do, not just a large state agency like us or a large company that has a law firm that has a lot of money, two things that everybody can do to help level the playing field are: one, be really creative and intentional about how you're using the tools that are out there. And two, think about the staff you have. Think about the people that you have and how can you use them to help access those tools and maybe train people to use those tools in a better way.
Gotcha. Now, Patrick, from a product and services providers perspective, right? You're building these things, helping people implement these things. What are some of the ethical considerations for you around a fair fight?
Yeah, absolutely. I think it's important to note that really no one knows how these tools will ultimately end up affecting the criminal justice system. Criminal justice system is very complex. Things that we introduce maybe for improving efficiency could have implications for other parts of the system, especially in the context of a multi-stakeholder system like we're operating in. Technology often does three things. It amplifies, it accelerates, and it focuses. And when you have those effects in a complex system, we have the tendency to sort of warp or twist the way the existing system currently works. And so projecting that out can be really hard. What we can say, though, is because of that complexity, we need to empirically evaluate these tools. It's not enough to drop something in and just let it go. We have to have a clear expectation around the effects that we anticipate, both the direct effects that we're hoping the problem will solve, things like speeding up discovery analysis, handling that sort of insurmountable flow of evidence coming our way. But we also have to consider some of the second or even what I refer to as N order effects of introducing these tools. So if we use this, how might others react? if we use these tools, how will that affect things that we otherwise care about, like the disparities or inequities in our system? Areas where we know that our system is not functioning as we would like it, is the introduction of these tools making those problems worse, or potentially having a beneficial effect on some of those challenges? So we need to articulate those things, and then we need to measure as we implement. And it's not enough. I see a question in the chat around, should we have a moratorium to study? My thought on that is probably not, but there's some nuance there. What instead how we should approach these particular challenges is what's referred to as iterative deployment, which means that we thoughtfully deploy these tools with clear benchmarks for performance and potential second and third order effects. And then we assess and redirect as we move forward. And we do the best that we can. One of the reasons why we have to take that particular approach is because the development, implementation, and use of these tools is by and large inevitable. Regardless of whomever is on this particular call and the decisions that any of the people on this call make, these tools are being adopted. And as people have pointed out, adopted at a faster rate than we can really keep track of. What we can try to do is ensure when that adoption happens, it's being done in a responsible way with accompanying empirical evaluation. So I think that is the point I would emphasize with regard to ethical adoption and use.
Mm, mm, mm. Uh, Aubrey, just briefly, are you finding that the courts themselves are concerned about resource balances between prosecution and defense when it comes to AI implementation, or are they more looking in on themselves? And I guess another question is between courts differences. We need some degree of consistency in our criminal justice system for
Yes,
people to believe in it.
yeah. So I think that where the court's role is like a neutral arbitrator of the facts and the law, the court's role is not necessarily resource distribution or equalization between prosecution and defense, and like shifting between those disparities. But I will say though, courts like historically have stepped in to ensure that there is a baseline of access that is available. Like a somewhat recent example is like law libraries, or providing like a Westlaw or a Lexis license that you can use regardless of your resources. And to like Jennifer's point of solos, that is accessible to them. It may not be their first choice, but it is accessible. It's accessible to the defender's office as well and the prosecutor's office. It's anyone who comes through the doors. So there's a baseline that is provided, and the court's role is not to make sure that one side doesn't have that advantage or the other, but it's to make sure that they're uh, assessing it equally, and though in how it's presented. And maybe just like a really quick, I know you said briefly, but a really quick just example of how courts are doing that with AI now is with court transcripts. So there's a court like nationwide shortage of court reporters, and it's causing like delays in scheduling and also just access to the resource that is pretty fundamental in cases. And so courts are exploring AI transcription as a way to bridge that gap. But also, Patrick, to your point about like going slowly, thinking about this, those that have already invested in AI transcripts are seeing the benefit of reducing the scheduling delays, lowering the cost of transcripts themselves, and creating a faster access to that like necessary record. But for all of those who have ruled it out, we're not seeing anybody permit citation to the AI transcript as that official record. In order to do that, a few courts have taken kind of two approaches. One is like digital timestamp of the digital recording as well as the AI transcript, or you have to request and then absorb the cost of having the AI transcript turned into an official record. But so they're not creating the records when they're not necessarily going to be used. It's also happening faster, and they're raising that baseline for everyone. It's applicable to everyone, and being available faster and usable. So it's kind of like the court supporting everyone the same way, bringing it in and making sure they have the same resources. And then I'll now briefly like the broader question on court to court. It's, I think, the same challenge that we've always seen with technology adoption in the courts. For the transcript example, if you already had digital recording, you can layer on AI transcripts on top. But if you don't, then you have to do two things. is a challenge for the courts. And it's similar in the way that they're structured is not the same. But I think that maybe AI might be kind of like a carrot on the stick, and encourage courts to say, okay, we have to get some of these fundamentals in place, and then we'll be able to move really quickly. And hopefully those that are already moving ahead are paving that pathway to be easier or well tested for those who are still kind of needing to build some of the fundamental technologies to utilize it.
That all makes a lot of sense. We're running low on time and promised folks question and answer period. So I want to do lightning round. We're running low on time because you all have so many great things to say, and this is too short of a web panel. I'll put it like that. So lightning round. Everybody cool with that? All right. Let's talk about risks. We can't ignore risks. Briefly, what are the main risks that stand out for you, and what are you trying to do to mitigate them? Just real quick, or maybe just name the risks, but also what you're doing to mitigate them. Can I start with Laura?
Yeah, I think the risks are lack of human review. And so we are trying to implement and constantly encourage and remind our prosecutors and staff that it is imperative that they review the product of AI.
Great. Jen?
Ditto what Laura just said. And then, like I said earlier, on the other side of that, risks that things are going to be coming into courtrooms, and how do we apply the rules of evidence to this new technology and make sure that only good software, good applications get in front of judges and juries.
Patrick?
I think the biggest risk is hubris and just thinking we know more than we do. And even for those folks who are adopting a more conservative posture, thinking that the existing systems work well enough where we don't have to continue to innovate. So I think we need to approach this next set of challenges with appropriate humility instead.
Aubrey?
I'll maybe tack on to Patrick's, but I worry about kind of a fail-safe and a backup. What happens when there's a outage or these resources become like too expensive and cost prohibitive, and we can no longer rely on them? Do we remember and have documentation of kind of the underlying things that we were doing before we were able to implement it? Cybersecurity attacks happen, power outages happen. We need to be able to keep the court doors open.
Wow, a great forgetting. That would be terrifying and awful. All right, then sadly, we're going to skip this section on implementation, which was going to be really cool, but you all have to come back for another conversation on management and implementation someday. Last for all, and then we'll go Q&As, lightning round. Biggest hope for, say, I don't know, what's a reasonable AI timeline? 18 months seems like a decade, but is it a policy? Is it policy? Is it practice? New tech? Laura, biggest hope.
Yeah, my biggest hope isn't new technology necessarily, it's maturity and how we use it. In 18 months, I'd hope we'd have clearer policies, better training, and a shared understanding across prosecution, defense, and the courts about where AI helps and where it doesn't belong. If AI works the way it should, it's going to free lawyers up from administrative work so they can spend more time on the human parts of the job, preparing cases thoughtfully, working with victims, and making better decisions. Ultimately, the goal isn't smarter technology, it's a justice system that works better for the people in it.
Jen?
So, the way I see AI kind of rolling out is like first internally, how can it help us be more efficient internally? Then scaling, and I think it talked about both of those things. But the future for me is how it can fundamentally transform the relationships we have with our clients. How can we use AI to connect more often and differently with the public and with the people that we serve? So I know that our IT department is sort of spinning about ways that we can use this technology to make public defense or make public defenders even more accessible to our clients through all sorts of things that we're imagining and hope to be rolling out within the next 18 months.
Tremendous. Patrick, and then Aubrey, I'm going to let you guys go back to back, and then we're going to do Q&As because I'm getting it in the chats.
Empirical evaluation. We need to prioritize it, and there's no reason why we shouldn't have it within 18 months.
Preach. Aubrey?
Patrick stole mine, so I'll just say ditto. I'd like to see some real lessons learned.
Great. Thank you all so much. You're fabulous. I want to do this again at 3 p.m. But we'll go to QA question and answers. Our first question is from Kevin Heed. I'm sorry if I am mispronouncing. An Arizona Court of Appeals judge has proposed a 3-year moratorium on the use of generative AI for core judicial work to allow for further study before any use. What do panelists think of such a proposal? Should judges be encouraged, discouraged, or even prohibited from using generative AI in making judicial decisions? Who wants to grab that first? Aubrey, you went off mute first. Go for it.
Yeah, I'll maybe start. Without looking at it and how they're defining core judicial work and any generative AI, I think like, just generally it's very difficult to go around a full moratorium. It can be really restricting and may prohibit actually that exploration in that time. And maybe I think like my initial reaction is you don't have to launch something, but maybe explore it and set some other safe use cases that you like or ones that you are already considering in that unsafe bucket and evaluate why they're unsafe, how to make them safe. But I think like a full moratorium kind of sets a tone and it's a pretty long time to set that tone.
Yeah. Patrick, you're going to get the second question. So you're going to get the second question first. So Laura, Jen, do you have a feeling on that? I'm kind of sensing a thumbs down from this panel.
All right, thumbs down.
Okay.
Agreed.
Agreed. Patrick, you agree? Do you want to be out of business?
Yeah, no, I mean, systems are really sensitive to their origin points, and this is potentially enough of an inflection that it's a new origin. And if we're not actually shaping the use of these tools right now, if we wait 3 years, we're going to miss an enormous opportunity to think about how we can better serve our communities.
Gotcha. Okay, back to you again, I think is second question. Don't know who it's from. How are companies thinking about the idea of consent when it comes to things like witness testimony? Is the idea that by having talked to police, they have consented to the use of their data with an AI tool? Rachel Littman asked this question. Thank you, Rachel. Patrick, I guess that's a question to you. Is that part of the ethical considerations?
Yeah, so maybe some nuance to layer in with regard to this. I think the question is potentially getting to, are you then able to train new models using that particular information? I think that's likely where the question's going, but correct me if I'm wrong, Rachel. We're currently not set up for that use case. The way our tools are working, the agreements that we have with all of the agencies we're partnering with, is that the data is not used to train models. We are using already trained models, and we're using context engineering to support specific use cases, but we're not fine-tuning based on anyone's data currently, and we're not using that data to train models fundamentally. Now, if you take a step back and say, well, do we trust OpenAI or these other companies? That's a totally different conversation. There's enough in the copyright world in particular to raise suspicion around how some of these tools have been developed. But if people are following their contractual obligations and all of their user agreements, et cetera, then there is no training of models or that type of use with regard to this data. So that's at least where we stand on it.
Got you. Jen, do you have anything on this? I'm curious how your office is treating fine-tuning your models, if you're doing any of that kind of work.
Yeah, it's always interesting to me because I think like, how is it any different than if, I get a statement in and I gave it to a bunch of lawyers to read and help me brainstorm a case, right? Like, so if we're using it to train models, I agree with you, Patrick. But one of the things that I always kind of say to my lawyers when I have a lawyer who's like freaking out over AI being used is like, what is the difference in what we used to do, which is sit around a table and talk about something, and putting something into a machine is essentially thinking through it and talking about it faster. So I do agree, but I do agree with Patrick that the line really is we shouldn't be training, or a private company shouldn't be using this data to train future models. But if a witness statement is coming in, as long as we're not disclosing it to anybody that we're not supposed to be disclosing it to and keeping it internally within the law firm, I don't really see the difference. I don't know if that makes sense, but
It does. I think it's it's sort of an aesthetic question almost.
yeah.
I think there's an important point around permanence versus ephemeral. And when we just talk about something, it's sort of necessarily ephemeral. It's sort of, in our memories, perhaps. But when we actually put it into bits and bytes, it actually has the potential to be a permanent record. And so there is a potential difference in that particular sense, and that's why we've exercised caution in that particular space. If it's proprietary, you're fine-tuning a model that has no potential for getting outside your organization. I think that's much lower risk than something that's not proprietary. If you're just going into the GPT store or something along those lines.
Great. Our third question is from Michael Freeman. Who is proofreading to ensure summaries and facts are accurate? Laura, maybe you can speak to this. I'm sure it's going to be different for different offices and whatnot, but Laura.
Yeah, sure. It's on the prosecutors or any of our support staff. It just kind of depends. And then like with officers, they've got the AI generated transcripts and it's actually creating their reports. It's on the officer. But then once they turn it over to us, it becomes our burden as well. So.
Jen, do you want to jump in on this one as well?
Yeah, so it brings me back to when the state of New Jersey was trying to decide whether or not we should adopt different rules, different ethical rules for the use of AI, and ultimately we decided not to. And the reason we decided not to is we went around and around and had a lot of conversations and then realized the same rules apply. The attorney is still responsible for anything submitted to court. If the case site is wrong, whether it was my intern that wrote the wrong case site or a fake case site generated by AI, it's still my license. It's still on me. I think one of the things that Laura talked about, and there's a danger when we talk about police officers, not necessarily in the context of I wrote a report and maybe I'm running it through AI to fix it or to do something with it. But I have heard now about applications coming out where they're having the AI watch the body camera footage and write a summary of body camera footage. And then the officer is reviewing that. That is where I see a lot of danger because now we don't know whether it was the AI that found the thing on the body camera or whether the officer actually saw it and remembered it. So I think in those cases, we need to be careful to put a lot of protection around having an officer write a report first. Then if they're going to use AI, that we know they used AI to review that report so that we know if anything changed from their initial observation versus something the AI saw that they didn't see. Just recently in New Jersey, we had an officer, a fire marshal, get on the stand and say, I put my report through ChatGPT and had it generate questions the defense might ask. And he said, and then this thing that I said about something actually came from ChatGPT. So now we don't know if his testimony was based on personal knowledge or based on something that the ChatGPT, lots of problems there. We won't unpack all of that now. But that's the kind of thing I worry about when it comes to the basic evidentiary rule that people have to testify based on their own personal observations.
We're dealing with, so many complicated questions come up. We could go for forever. And then there are all the cognitive, all of the sort of cognitive theories, automation bias, and all of these and Patrick, you've spoken with me about confirmation bias in these tools that the models are built to please as well. So it gets quite challenging. Then there's, of course, this really weird question, which is, can an officer use an automated report to refresh their memory on the stand? Like, what does that even mean? I don't know. Fourth question, getting close to our last, Yuki Kui asks, how long did it take to go from the initial idea for the AI tool to actually deploying it and using it in the DA's office? Jennifer, that's you again. I know that design and build cycle was pretty interesting.
Is that for Laura in the DA's office or?
Oh, in the DA's office. I apologize. Sorry. DA, yes. And then I think maybe Jennifer, you can jump in again. Sorry to leave others out. Aubrey, you can maybe jump in and talk about your tools too, but talk about this design build cycle.
Sure. So we're actually still in it. We work actively with Patrick. We meet weekly and, provide tools, feedback to the tools that they're implementing. Patrick, you may have a better idea on timeline on when you started with us. But we're well over 12 months, I think, at this point, and actively growing his application based on the input and feedback that we're providing.
Yeah, we're using that method that I talked about, iterative deployment, where we continually improve the software that we've developed. But if you're looking from like when did we start exploring this to when did we have software live, it was just a couple months. Short agreements process, and you can get tools built and deployed. Now that we've built a number of different workflow tools, we can move very fast with an office, especially within procurement thresholds. Our work is philanthropically subsidized, which is nice, because we don't, right at this point, pass the full cost on to the office that we're working with. So that's another advantage as well.
Aubrey, in your experience, is sort of a 12-month, 6 months, 12-month timeline for building and deploying?
So I'll say I don't know if I'm the problem here, or courts maybe just think of things a little differently. But in the two projects that I've been largely on, from ideation through build to launch, it's taken significantly more than 12 months. For example, worked on a chatbot that would be public facing with the Alaska State Courts, and that project was estimated to be 4 months. It's taken 18 months. They're like launching any day now. But it took a really long time. But in part, that's because it would be used directly by the public. There was a lot of iteration in the process that Patrick described, but the risk is there a little bit different, and that is provided to public, not expert users. And so there's a different process. We did user testing throughout, but then improved it instead of launching it. And for the credit card checker that I mentioned earlier, we had some technical delays in integrating with different systems that are owned by different people in the courthouse. And so and then process needs to be redesigned and changed as well. So I'd say longer, but I think for maybe different reasons than you might see in a prosecutor or defender's office.
Still impressive. A really nice website can take an entire year to build and deploy. And these are a lot more intelligent than a website. We have one more question, but I don't think we're going to quite make it. Jen, do you want to talk about your design cycle just briefly? And then before I forget and everybody jumps off, I got to plug in 1 month, same time, same place, the final in this series, AI and Incarceration. We've got directors of corrections from Utah and Idaho. We've got folks working on building tools for reentry, and an academic. Okay, Jen, and then I'll close it out.
Yeah, so our design cycle was about 9 months till our appellate attorneys were trying to break this thing and make it better and fine tune it. And then it'll be about 18 months for like a full rollout. New Jersey has this Office of Innovation. This is very, very different than normal state government timelines, which would be years for software in New Jersey or years for something like this. This Office of Innovation is really neat in that it's a kind of agency within state government that where the red tape is essentially cut so that they can build things for state agencies faster. It's very, very cool and an interesting idea for people out there who might be part of other government agencies to see if it's something that you can get started.
Fabulous. Well, we're at time. Thank you all so much. Thanks, attendees. Thanks, John Jay. And we hope to see you next month.